Hello to everyone that's taking the Law Office Management class. I'm Brian White. I'll be your instructor. And this class ideally would have been taught in person because it typically is a class where we instruct by showing. We're going to try to translate that to the online medium. We've put a lot of planning and thought into it, and I hope that it shows. This class basically will have 10 weeks, and each week will have a module of material, and we'll talk about that more in detail in a second. But first, I want to tell you that my contact information is in the syllabus, and I want to emphasize that the very best way to get in touch with me is my office email address. It's bamalawyer@gmail.com. For those of you who don't know me, I'm an adjunct professor. I've been doing it for almost 8 years now, maybe closer to 9. But point is, I have a job that is my primary occupier of my time, and that is the email address that I check daily, every day, on the hour, compulsively. So use that one if you really need to get in touch with me. On a daily basis, I'll check my Calhoun email, sometimes twice daily, but I probably won't check it on the weekends. So again, my personal professional email, bamalawyer@gmail.com, is the best way to get in touch with me. My office phone is available to you, 256-355-1100, extension 13. And my cell phone in case of emergencies is 256-426-8317. So if you communicate with me by email, put PRL282 in the subject line so that I can spot it more easily. So back to the course content. The first thing I want you to do, as is indicated in the course content, is to do the Blackboard orientation and certificate. If you've done this before, which I'm almost certain you probably have, just please do it again. All right. It'll be on record in this course, and will prevent there from being any mishaps due to a lack of familiarity with Blackboard. So each week we will have a module. The first two are built out already, and the remainder of them have just the information about the assignments, not the assignments themselves or the reading material or anything like that. But I've gotten as far as the first two, and we'll be working on the others shortly. So if you can work ahead, you can work ahead if you want to. The important thing is that by Sunday at midnight of each week, you have the previous week's assignments done. I want to stress that deadline keeps my grading current and you having a steady stream of feedback about how you're doing in the course. So each week there will be a lecture of varying length. Then there will be an assignment or two, a discussion board in every week, and some kind of research every week as well, utilizing Lexis, which is the software or the system that we have available to us at Calhoun. It happens to be the very best research tool for case law, statutory law, secondary resources, and all that. So I want you to become familiar with it. All right. So I will endeavor to have every module completely finished out by Monday morning of a given week. So at the end of week 2, that following Monday, week 3, by mid-morning, all the information, all the material will be available. If there are any questions, let me know. Again, best way to get me is by my email. So the next thing we'll do is just go ahead and get into the lecture that I want to present on the ABA guidelines for the implementation of paralegal services. The guidelines are officially known as the ABA Model Guidelines for the Utilization of Paralegal Services. And they consist of 10 rules or 10 canons. Some of them are basic to me as I look at them, but are important things that I believe we should all be aware of if we employ paralegals, mainly because of guideline number 1. It states that the lawyer is responsible for all the professional actions of the paralegal. So if that paralegal is working at the lawyer's direction and should take reasonable measures to ensure that the paralegal's conduct is consistent with the lawyer's obligations under the rules of conduct that govern the lawyers. What that all means is a lawyer better know these model guidelines so that the lawyer can train paralegals who work with them thoroughly, setting expectations, setting boundaries about what the paralegal can do. The most important thing is that when a lawyer delegates, the lawyer is still ultimately responsible. That's the spirit of guideline 1 and 2, which guideline 2 says that the lawyer can delegate tasks normally prescribed to lawyers unless there's some rule against it. But the lawyer is ultimately responsible for the work product. In other words, I might have you draft interrogatories, requests for productions, requests for admissions, but those absolutely must be checked and approved by the lawyer himself or herself, because there is no saying, well, that's my paralegal's mistake. My paralegal's mistake is my mistake. So guideline 3 talks about some things that are not delegable to a paralegal, and they are establishing the attorney-client relationship, accepting a case, rejecting a case, accepting a client as a client of the practice or the firm. Fees can't be set by the paralegal, but there's a great deal of communication that may go on with the paralegal about when the fee is due or how the fee might be paid, or communicating flat fees, which may require some interaction, generally for purposes of knowing what kind of case someone has and indicating whether or not that flat fee would be applicable, and what flat fee would be applicable, such as in uncontested divorces. It matters if there's real estate. It matters if there are children, and because it determines, if a person has children, there are about 5 or 6 more forms and pieces of paper and agreements that have to be utilized in coming to a sufficient settlement agreement for the divorce. So there may be flat fees that are based on those criteria. Whether or not a lawyer has to get involved in drafting a qualified domestic relations order, generally a fairly complicated and time-consuming practice. But those are the things that in training your paralegal, they can interact about some expectations about fees, but ultimately the fee can be represented if it's on a schedule of fees. But finally, the lawyer is the one who approves and sets the fee. There can be discussion about it, but ultimately the lawyer must make that determination for a client. And certainly paralegals cannot cannot render a legal opinion, cannot formulate and write or compose the legal opinion, but they can support and reiterate what they know to be advice given to a client. So imagine again a domestic relations situation where perhaps there's some dispute, but the lawyer says, you would be in a very precarious position if, based on what I'm hearing, you simply withheld visitation. So don't do that. All right. The paralegal may deal with subsequent phone calls, second guessing, and so on. And the paralegal might reiterate, well, you know what attorney so-and-so told you, and that's what you ought to do. And of course, you need to train your paralegal to say if there are significant changes in the variables, you say to the client, well, let me communicate to the attorney, and that lawyer will be back in touch with you very soon. So you've got to be cautious, even if they're simply reiterating and supporting advice you've already given, because if there's a change in some factor on which you base your opinion, you've got to have your paralegal trained enough to know that perhaps they need to communicate with you, or have the client communicate with you, or say, you and client so-and-so need to have another conversation. I think that maybe you need to update your legal opinions, but the responsibility for formulating and rendering legal opinions to the client is the lawyer's alone. Those in Guideline 3 are non-delegable duties. Guideline 4, the lawyer is responsible for ensuring that people who deal with the paralegal understand that the person is in fact a paralegal and not a person authorized to practice law. The term, or the if a paralegal is on letterhead or has business cards, they should be delineated as being in the role of a paralegal. A paralegal should not be sent to court for a lawyer except in the most routine of circumstances, simply to deliver a message, perhaps to say that Attorney Smith is still in Judge Jones's courtroom, or is still in the middle of some trial in another county, and providing that kind of information, but not going to court to do anything or walk a client through any process in the courthouse. Now, the necessity of delivering messages and so on has kind of depends on the ability to communicate with the judge's office. If they have a clerk that's accessible, a email system that is checked, and a judicial assistant who remains in the office versus in the courtroom, even then they can be communicated with by email if they, all that has to do with knowing your judge, and those sorts of communications should be maintained by the lawyer if at all possible. So, we can talk about that more and answer questions more. Guideline 5, I've already discussed in the process of talking about 4, when it comes to letterhead and cards and perhaps phone messages and that sort of thing. So Guideline 6 says that the lawyer is responsible for taking reasonable measures to ensure that all client confidences are preserved by a paralegal. There should be in every paralegal lawyer employer relationship some document that describes and reiterates the importance of keeping matters confidential. Let's face it, we come into contact with all kinds of interesting and salacious information working in law offices, and I, as a lawyer, am responsible for making sure that my paralegal understands that in their position they are not to be participating in gossip about firm or client business. It's just fundamental because if you can do harm to a client, get in trouble with the bar association, and then ultimately, if your law firm is known to be a place where your information winds up on the street, your clients will go elsewhere. So, rule number 7, or guideline 7, a lawyer should take reasonable measures to prevent conflicts of interest resulting from a paralegal's other employment or interest. Maybe most immediate would be the concern of a paralegal who has moved from one firm to the other. Is there confidential information that paralegal might have if from their other employment about ongoing litigation or ongoing clients that would be of interest to your firm? So ultimately, those would create conflicts for the lawyer, perhaps maintaining a role in a case or taking a case. So that's something that has to be examined when paralegals change employment within the same town or area. And then other concerns and outside interests of the paralegal could create conflicts of interest. You know, perhaps their work on a nonprofit, or perhaps they're being involved with certain advocacy groups. Just be alert to those things that could create conflicts of interest and potential motives for misusing information that the paralegal might come in contact with as a result of his or her work. Guideline 8 involves paralegal billing for their time, and there's particular things for which a paralegal can operate more cost effectively for a client, like drafting discovery or drafting correspondence. Those can be done more cost effectively by a paralegal versus a lawyer who may bill $200 to $300 for his or her hourly rate. I don't have a solid feel for what the going paralegal rate is, but the lawyer can charge for that, but it must be in the billing statement carefully delineated as work done by the paralegal. And it's in the interest of the lawyer to do that just for purposes of good business, because it alerts the client to the fact that the lawyer is trying to delegate what can be delegated for cost-saving purposes. Guideline number 9 talks about splitting legal fees, which is forbidden. Um, the gray area becomes bonuses that are paid, but the bonus cannot be contingent on the outcome of a case by advance agreement. Bonuses might well be contingent because the lawyer may be getting a contingency fee, and there may be money available to pay bonuses that might not otherwise be there. But by advance agreement, you can't say if you work really hard on this case, there'll be a bonus of X amount or percentage or anything like that. That is just simply fee splitting. All right. The final guideline involves paralegal education, and it is certainly to the benefit of the paralegal and the lawyer to have paralegals educated in substantive aspects of the law. It makes them more effective as frontline operators on discovery and drafting certain things if they in fact understand the law in a way consistent with what a paralegal should know. Certainly all the CLE in the world is not going to replicate the benefit of a law school education, but a smart paralegal is a bonus for a lawyer whose more thorough legal education may be very dated. I'm rolling up on 30 years from starting law school, 27 on finishing law school. So I'm very, very aware of the fact that there are things I don't know that the paralegal could access, and it would be an opportunity for me to learn. The other thing is that technology and just automation of office procedures and so on are things that paralegals ought to be kept up to date on, and it's the lawyer's responsibility for facilitating that for the paralegals' benefit, their professional development, and certainly for the lawyer's benefit too, because a lawyer who generally in a small firm or solo setting who could employ a paralegal isn't going to be a brand new lawyer. You don't necessarily come out of the chute with the resources for a lot of staffing. So you're going to be dealing with an older lawyer, perhaps a recent graduate of a paralegal program, which means that they're going to have a fresher education. The paralegal is going to have a situation where they may well know much more about things such as PowerPoint. Did not exist when I went to law school. So someone under 30 is at a distinct advantage for knowing that and helping enrich my practice with those kinds of things and perhaps teaching it to me. So the education of your paralegal and continuing education is certainly just good business, and it is good for the employer-employee relationship because it shows that the lawyer is interested in the person's professional development. Hopefully the lawyer's growing, hopefully the paralegal's growing. If that means they become more valuable and go elsewhere and do other things, great. If they don't and remain with the firm, the professional growth for the paralegal becomes inures to the benefit of the lawyer. So either way, it's a smart thing to do, and that's how it's worked its way into these 10 guidelines. So there's an activity, a discussion board, and then there is a another assignment that deals with the specific um, specifics of these guidelines for utilization of paralegal services. Uh, and if you have any questions about anything we've talked about here or anything that might come up in those assignments, please let me know. All right. Thank you, and we will see you next time.